Greetings and welcome to the U.S. LawShield YouTube live event, Crucial Brandishing Mistakes to Avoid. I'm here today with independent program attorneys Richard Hayes.
Good morning.
And Emily Taylor.
Good morning.
From the law firm of Walker Taylor. And I'm Kirk Evans, president of U.S. LawShield. So today we're going to take on a topic that we get a ton of questions about, and that is brandishing. Not only do we get questions, but we see members and non-members alike get in trouble for mistakes with brandishing. So to start that off, let's start it off with what is the legal definition of brandishing? We'll give that to Mr. Hayes.
Well, what we see is there's no uniform definition across the 50 states. And so when we refer to the term brandishing, we mean it kind of colloquially, that we're talking about exhibiting a deadly weapon in a way that would be threatening to other people. And typically this is outside of a holster, it's outside of a sheath, it could be outside of a pocket, but it's displayed, intentionally displayed in open. And we have a couple states that maybe they call it brandishing, but the vast majority of states will just call this some kind of use or exhibition, or, you know, that's just kind of the term people throw around. But there isn't a rock solid legal definition to work off of.
All right. So what I did hear you say is that some states do actually define brandishing?
Yeah, you'll hear the term used from time to time.
Yeah, very few. Some states actually do have a crime they call brandishing, but that is very, very rare. Most states, I mean, it's called things like unlawful exhibition or unlawful display, deadly conduct maybe, unlawful carrying. But, you know, every once in a while you do see a state that has a crime called illegal brandishing or unlawful brandishing.
Okay, so if our viewers here wanted to go back to their state and look up the definition of brandishing in their state, what would they do?
They'd probably go to the assaultive chapter of their criminal code or their penal code, or you know, depending if they're still just in raw statute form, that's where you're probably going to look. And it's going to be around the section of law relating to an assault is what we see typically. And so, you know, what is usually brandishing is some type of assault. Every state, virtually every single state has an assault by threat, where you are either, most people don't say, I'm going to kill you. Sometimes they do, but you manifest in your actions my intention that I intend to scare you, that I'm going to cause serious bodily injury or death. And so with that assault plus, you know, we have our deadly weapon. That's where we usually find where these brandishing statutes live. In Texas, we would call it aggravated assault with a deadly weapon. We have our assault, you know, hey, I'm going to kill you, or I manifest my actions by demonstrating based on my behavior that, hey, I intend to cause you serious bodily injury or death. Plus, there's a use or exhibition of a deadly weapon. And so that's what aggravates it. It takes that assault and it moves it up a degree.
Yeah, but I think to make it more complicated for people who are trying to go into their state's law and figure out where this lives is there are probably multiple different law violations for the same action, because almost every state sort of double or triple criminalizes brandishing. So, you know, you've got, you know, I mean, I can say here in Texas, we've got aggravated assault with a deadly weapon, we've got deadly conduct, we've got potentially disorderly conduct.
Intentionally displaying a handgun outside of a holster. Yeah,
I mean, so we've got, I mean, multiple crimes, and most states will do this. So, you know, it really, your question as to how does someone go into their state's law and figure it out, it's really difficult, because if your state doesn't call it brandishing, which it probably doesn't, you're going to have to go in and you probably have multiple different ways that brandishing is criminalized. And good luck trying to find it in your state's code by yourself, because it is not going to be easy.
Well, so then even if you did find the definition, say I'm the responsible gun owner, and I want to go look up my laws to make sure that if I'm doing this, that I'm staying on the right side of the law. Is there any way the normal gun owner can do that?
Oh gosh. I mean, that's really tough. I mean, you know, Richard's right. You try to find your state's, okay, this is where our code lives. It's probably on a government website somewhere that is not well maintained and is really difficult to navigate. And then you're going to have to try to look up, okay, I'm going to find the criminal section of the code, and then I'm going to go to assaultive crimes. I'm probably also going to go to weapons crimes, and I'm going to slog through and try to figure out which ones apply. I mean, other than that, because your Google search, I mean, is not internet lawyers, right, who are just typing on forums. It's not a good idea to trust that kind of material. So I don't have if you don't have a criminal lawyer who specializes in firearms or who is very well versed in firearms to call, I don't have a good way to tell you how to find this information.
Yeah, because, and I think it's a good reminder that generally the law tells us what we're not allowed to do. You're never going to go, open up a law book and it's going to say you are allowed to do X, Y, and Z. So we have to work backwards, and we have to see what are we not allowed to do. And because this information could be scattered, among many codes and make compounded times 50 or however many jurisdictions we're operating in, it's very difficult for a regular person to, know what are my rights essentially? When am I staying in bounds? And I would say, the only way to know is you have to speak to an attorney, or you have to really devote some time to figuring out where this law lives.
Yep.
And let me say, as a good head start, this is not going to get you all the way there with all the nuances in your state. But on the description to this event, we have an article called Everything You Need to Know About Brandishing. And that's a heck of a good start. But again, as these fine folks have said, you really need to talk to a lawyer in your state before you can get to the bottom of this stuff. So let's jump to this question we get a ton. For those states that allow open carry, we get folks that say, well, wait a minute. Okay, so my gun is visible. I'm walking around, somebody can see it, and they obviously can infer that I would use this gun if I needed to. Is that brandishing?
Probably not. And, I can work from Texas as an example, because if you're doing something that's lawful, here in Texas, if you're carrying under the authority of Texas constitutional carry, or you're carrying under the authority of a license or permit, a lot of states are that way. Let's say you're qualified to carry openly in your state. Texas imposes, I know a lot of states impose this, a holster requirement. You got to keep your handgun in a holster unless you're justified for some other reason. Say you're defending yourself, you're defending another person, property. At that point, maybe you would be justified to remove the handgun from the holster in defense. But just keeping it in the holster, is that in and of itself a crime? Probably not. But what we see is, and this is where we kind of fall into this gray area, is what if we have openly carried holster plus some action by the wearer? Maybe they're pulling a shirt back, maybe they're pulling a jacket back, or maybe they're saying something. In which case, I don't know. What do you think, Em?
Yeah, or even just, and this is something that comes up quite a bit actually, because, those of us who, carry sort of regularly, we get into this kind of habit that is, good or bad, depending on who you ask, of sort of adjusting and checking and making sure the firearm is there. So let's say we are in some sort of verbal altercation and I'm not thinking about it. I just go to check my pistol, right? Because I'm used to doing that. And all of a sudden you're thinking, I'm yelling at you and I'm touching my gun, right? Has that escalated what was before lawful open carry to some sort of brandishing act? It's very interesting. I think another interesting point is that lots of states include in their, quote unquote brandishing laws, whatever they're called, aggravated assault, they include that you are doing something while using or exhibiting a deadly weapon, right? Use, if you're just open carrying, definitely not going to trigger that. But is just open carrying a pistol exhibition of a weapon while you are committing an assault because you're yelling at someone or what have you? I mean, I think that is a really interesting question, and it's one that is going to be tested, I think, more and more as we go forward, because that word, exhibit, I mean, it can mean almost anything.
And the way that it comes up in a practical application, because, a lot of people think, okay, well, let's say we have this gray area. Well, it's to law-abiding gun owners' detriment, this gray area, because police have probable cause. Maybe their standard is very low. I think you probably committed whatever this is called. You probably committed this brandishing, and we'll let the courts figure it out. And that's, very life disrupting. Getting charged with a crime is very, very life disrupting. And so it's an uncomfortable place to be. And I understand the desire to understand, hey, I'm a normal person. I want to carry to protect myself. If I run into this scenario, the problem, what if I have to, or what if I uninstinctively do that?
Yes.
What do I need to do to guard against that? And unfortunately, there's just not a great answer.
Yeah, no, I wish I had a good one. When Texas actually instituted open carry, we all went to the forums hosted by the government, by the district attorney's offices, and we're asking this specific question. And all they could give us were essentially promises, like, we promise we're not going to arrest people, just for open carrying in this kind of situation, which, is worth absolutely nothing, right? Because ultimately, district attorneys, sheriffs, these are elected officials who really, really want to win re-election, right? And so we see, and I think particularly now, political winds blowing towards, people. I mean, there's a rise in violent crime across the country, right? I mean, particularly, I know here in Houston, it's been really, really bad. It's not a rise in gun crime, it's a rise in violent crime. But it's really easy for these guys who are elected in charge of keeping us all safe to say, this is a gun problem, I know how to fix it, right? And then all of a sudden these promises they made, oh, don't worry, gun owner, just your act of open carrying isn't going to be considered brandishing, we're not going to arrest you for that, is worth absolutely nothing when they can run on re-election saying we've gotten this many firearms off the street or we've prosecuted this many gun crimes. It makes it look like they've done something.
Yep.
Let's do a quick follow-up for those states that don't have open carry or folks that like to conceal carry. Say I'm conceal carrying and I am printing to where it's obvious that I have a gun. Could that in any way be brandishing?
Well, in most places, printing is not the same thing as brandishing. But remember, every state's law is going to vary. So you really do need to check your state's individual law. In most places, though, as long as you can't see the actual firearm itself, you are probably okay unless you're in a very, very highly restrictive place. Richard, do you want to add to that?
Well, I would just say, I can give Texas as an example. If every part of the handgun is concealed from plain view based on ordinary observation, and we're talking about laying eyes on, a slide, a handle, the tip of a barrel, if no part of the handgun is visible, then it's going to be considered concealed in Texas. I mean, you could be wearing a Spider-Man costume with a gun, with a perfect outline of a handgun, pressed against your body. That's still going to be considered concealed in Texas, and that's not going to be considered open carry. And so for that reason, it's going to be kind of an uphill argument to say this person's brandishing.
But for those states that do criminalize open carry, then you have, let's take the printing out of the equation. Let's just say that you start open carrying or your handgun, normally most of these states have an element of intentionally revealing.
Right.
But, just to be accused, let's say hypothetically you're in a state that does not allow any kind of open carry. Your jacket gets tucked in and all of a sudden your firearm is revealed. And you are open carrying. Now we have a situation where that's a really easy brandishing crime to charge, right? Because all they have to do is say, well, sure, it was, you come into court and you testify that it wasn't intentional that you revealed your gun, because at that point we're not talking about threats, we're not talking about touching it, we're talking about you live in a no open carry state, and we have seen that gun, boom, brandishing.
Gotcha crime.
Yes, gotcha.
Let me do one follow-up there. So say you are printing, it's obvious that you have a gun, the bulge in your jacket, and then you combine that with some type of words or gestures.
That's an interesting scenario. You see that with robbery. Person goes in with a jacket, they are holding, they have their hands in their front pockets and they're saying, empty the register. And the assumption the person on the other side of the counter has to make is, this person is holding me at gunpoint and I am, they're forcefully taking my money from me. So would that be considered brandishing? I don't know. I don't know that it would be. It would definitely be a use or exhibition.
They would make the allegation.
Yes, they're absolutely going to make the allegation.
Would it stand up and,
correct,
in front of a jury?
And that's why it's important. Brandishing doesn't necessarily mean just, holding your gun on a silver platter out in public saying, hey, look, my gun's out here, I'm brandishing now. It could be, just the use or exhibition. So that's why they usually try to combine those two elements. So would that use, holding a gun inside of a jacket, even though it's concealed from public view, is that using it to create that threat during that robbery? Probably yes. And so in that scenario where we have that use and exhibition combined, which we see frequently, that would probably qualify as a brandishing.
Yeah, it's interesting.
All right. Then the big question we get is brandishing a felony.
So this is another one that varies not only state by state, but probably even within your own state. You have multiple crimes. Some are felony crimes, some are misdemeanor crimes. Now, the actual, and again, we're talking about brandishing as though that's a crime in and of itself. It's going to be called something different in every spot, right? But there are going to be instances, we're talking about, we mentioned Texas earlier because that's, of course, where our familiarity most lies. If you have what we call a disorderly conduct, which is a brandishing charge here, right? Intentional display in a public place in a manner calculated to alarm, that's a misdemeanor. However, aggravated assault with a deadly weapon, right? So let's say you take that firearm out of its holster and you're threatening me and I take it out, I pointed at you, that's definitely aggravated assault with a deadly weapon. It's also brandishing. That is a felony. So probably whatever state you live in, there is at least one felony and at least one misdemeanor brandishing crime. It just depends on what you're doing along with the brandishing, what you're going to be charged with.
Yeah, I mean, I had a client who was selling flags on the side of the road, and from his perception, he saw his son, a very much larger man, push his, I think he was maybe 14 or 15-year-old son, and he went over to intervene. Hey, don't push my son, obviously. And the guy turned and started charging towards him aggressively, and he pulled his handgun in the low ready position. Hey, stop. I mean, that would definitely be considered a brandishing. Mm-hmm. Now, what we do in Texas, and a lot of states do this, like Emily was saying, it could be charged as a misdemeanor, could be charged as a felony. The scary part is, for the same conduct, what we see is brandishing, when it's charged as a felony, it's usually held to the same standard as if you had actually shot the person.
Yes.
Or if you caused serious bodily injury to the person, not killing them, not murder. But we see this show up over and over again. The mere act of pulling your gun out of your holster could be treated the same as if you shot the person and they suffered a serious injury. And in this case, the threat was stopped. The person went along their way. Police said he was in the right. So there wasn't any problem there. But we see where that was an appropriate use of force. Just if you can stop the threat by just holding the gun out as opposed to shooting somebody, logic would dictate that's what you want to do in that scenario. But then we have the law coming up behind you and saying, well, we're going to treat it the same as if you shot him. Yeah. And so we have a weird incentive structure we see show up.
I have another client story that really, I think, demonstrates this. So we had a client who was threatened outside of a grocery store by a really aggressive dog, and it was very large, and it was no owner in sight, and all the aggressive points, right? Hair on end, lunch, on its haunches, growling, going to, about to lunge at him and bite him. And he took his gun out, pointed at the dog, didn't have to discharge it, but ultimately, there was lots of commotion. The dog got sort of distracted, and he was able to get back to his truck. And because he had pointed the firearm towards other people behind the dog, he was actually arrested on the felony charge. And then ultimately, we made a grand jury packet and they no-billed the felony. And then for the exact same actions, he was charged with the misdemeanor because the county just did not want to let this go for some reason, maybe the political winds that we were talking about earlier. But for those exact same actions that he took, he was first charged with the felony. Grand jury said absolutely not a felony, and then he was charged with the misdemeanor. Same instant, same actions.
Wow. All right, so I'm the responsible gun owner, researcher, all the laws, and I want to make sure whenever I brandish, it's only the misdemeanor kind. How's that going to work?
I have no advice for you,
okay.
Unfortunately.
Okay, and basically impossible. Right?
Basically impossible.
All right, so now let's get to the big one, and we get this question all the time is, all right, this sounded horrible. The last 15 minutes sounds terrible. Can I not brandish or display my gun to stop a threat in self-defense? Can I do that or not?
Well, we talked about our basic self-defense principles. Do you want to jump into that?
Yeah, sure. And so, we have lots of different factors at play: immediacy, proportionality, reasonableness in response to an unlawful threat. You have all these basic guiding principles that we have with self-defense. And, and like we were going back to about that incentive structure, why are we going to punish this person the same as if they shot and caused serious bodily injury, as if they just pulled their gun out? But one of these overriding principles that we see come up time and time again, and that juries really latch onto, is using the least amount of force necessary to stop the threat. And, we saw that in the Kyle Rittenhouse case. And I think that's a great point to reiterate. We don't shoot to kill. We don't shoot, pull out guns to scare people. We pull out, or we display, or we brandish to stop the threat. And if we can stop the threat by brandishing, I will tell you, a jury will be much more forgiving than if brandishing would have stopped it and a person discharges. Even if they would have been justified in discharging, they would prefer that just the brandishing alone. If you could have stopped the threat, they want that, wouldn't you say?
Oh, yeah. And, remember, and Richard hit the nail on the head here, the least amount of force possible to stop the threat. So imagine someone coming at you with a crowbar, right? You take out that firearm, you point it at them, that stops them. You don't have to discharge. Brandish in self-defense, probably perfect. Whereas that same guy comes at you just with his finger pointed, and you, same action, take out the firearm pointed at him. Well, that's probably not the least amount of force that would have stopped that particular threat. Now, again, my lawyer disclaimer, every situation is different, right? I mean, I know you're going to say, but what about this? just hypothetically, in the simplest of terms, the same action of brandishing, it's got to be that I like to think of it as just like that little featherweight difference that's going to be a little bit more than what they're doing, that's going to stop them. That's probably your legal brandish, right? As opposed to, like what Richard said. And we all know, those of us who've been carrying for years and years and years, the firearm is not a tool to get your way, right? This is what I absolutely need to do. It is the lowest level of force on that force continuum that's going to stop the threat right in front of me.
Right. So someone wagging their finger at you, you draw your weapon, jury's probably going to view that as too extreme, but if the same person had stabbed you the week before, it might be appropriate.
Exactly. You just changed the facts on me, right? Which is what lawyer disclaimer, all the facts are going to change, right? But yes, absolutely different story then, right? So you need to look at your exact situation. I cannot tell you what all of the facts and circumstances surrounding your exact situation are going to be, but whatever those are, it's the least amount of force.
Well, so let's take some questions now, because we're getting to the questions about these are some facts.
All right.
We'll give this one to Richard. This is William asking, is it brandishing if you open carry in front of a contractor at your property and you do this shortly after the contractor starts working?
All right. Well, that's an interesting question, William. Probably not. And most states will allow, and again, there are some states where this is going to be criminalized, but most states are going to allow for the unlicensed possession of a handgun on your own property, and most states will allow you to open carry or conceal carry on your property. And so, assuming that it's in a holster, hanging out with a contractor, you're on your own property, I can't imagine a scenario where that, would be considered brandishing. If you're griping about the work that the contractor is doing with your hand on your gun, maybe, we can throw in a little fact here or there that might change our calculus, but just the simple act of carrying, assuming it's legal in your state, in the presence of a person working inside your house, I can't imagine that being brandishing.
Yeah.
All right. Well, here's another one. John asks, so a criminal is stealing my car. I draw my weapon to stop him and hold him for the police. Is that brandishing?
Ooh, so now we have invoked something else as well, which is potentially citizen's arrest. I will say, and again, every situation is different. If your baby is strapped into that car, much different situation than if you just look out from your very safe home and you see somebody, rooting around inside your vehicle. If you cannot engage over property alone, we always recommend that as your first course of action, right? Because like Richard was saying, let's say that, let's say someone's trying to steal your car, you take out your weapon, you point it at them, and then they do something and you shoot them, right? Even if ultimately you're found not guilty at trial, you are arrested for murder, it is going to change your entire life. So if you cannot engage, that is the best first step. But now we're talking about, okay, they are doing something. Let's say that it is lawful in your state to protect theft of property with, let's say, again, in your state, brandishing is just a use of force, not a use of deadly force. There's some states where that's actually not true. But in most states, brandishing that weapon is a use of force. You can protect property alone. Great. So you are lawful there. Then you do have to worry about, can you make a citizen's arrest for what you're doing, which is essentially what you've done when you hold someone there after personally witnessing a crime. Those laws vary state by state as well. Bear in mind, you've generally got to have personally witnessed. In Texas, it's a felony or a breach of the peace. That's actually pretty consistent state to state as well. Felony or breach of the peace, a law that sounds a lot like that. And you can't hold them for any longer than was absolutely necessary. And then, of course, there are civil implications that I won't even
And then I'll add one more fact. What if they start running away?
Right. And then probably if they're running away, you can't discharge your weapon anyway. So
it's no longer immediate.
It's no longer immediate. So yes. So the answer, John, and that's a very interesting scenario, and I think it's one that comes up a lot and people think of a lot, is if you do have to engage, in most states, I don't know, Richard, you can agree or disagree. In most states, you are probably okay simply to use that level of force and hold them, but you need to know your state's law backwards and forwards before you engage in that activity, because there are lots of places where that won't be true, and then lots of situational factors that would make it really, really unfortunate.
Yeah, completely agree.
Ooh, so here's one that brings up a whole nother kettle of fish. So in the finger pointing example, say you respond not with a gun, but with pepper spray.
I love pepper spray. I mean, I just not
and not shooting, but
You
display.
put it on pizza, you
say
put it on
you
tacos.
say you display pepper spray.
yeah, no, and I'll let Richard tackle this one, but just as an intermediate weapon, I think that pepper spray is just the best thing ever. So go for it.
Yes, well, and really because, like Emily mentioned, that use of force continuum where we have aggressive verbal commands all the way to shooting and killing someone, pepper spray falls on the lower end of the spectrum, and virtually every single state will consider it a use of force and not deadly force because it'll hurt, but it won't cause somebody to die most of the time. It won't cause somebody to lose permanent protracted loss of a bodily organ or something like that. And so most states, in some states, there are a handful that criminalize certain pepper spray. So you got to look this stuff up. I'm looking at you, New Jersey. But they say, hey, assuming that pepper spray is legal, it will constitute a use of force. And so if you would be justified in punching, grabbing, tackling, restraining the person, in that scenario, because that would be considered a use of force, a use of pepper spray may be appropriate under the circumstances.
I have never, ever, in all the years of doing this, had a client charged for any sort of offense by simply displaying pepper spray.
Oh, that's true.
Most of our brandishing crimes, right, say that it has to be a deadly weapon that you're brandishing.
Right.
And because of what Richard's just gone through, that pepper spray is generally not deadly force, it's not a deadly weapon. Now I don't recommend just tossing it about and trying to scare people with it, because then you've just probably got like a simple assault. You've got a different crime that's not a brandishing crime. But that's I think a wonderful reason why pulling out that pepper spray is a great intermediate step if that's the least amount of force that you need to stop the threat. Because a few states maybe are going to make that a brandishing crime, but it's going to be very, very, you're going to have to live way too far west or way too far northeast for that to happen.
All right. So Andrew, and actually, let me follow that up. So we mentioned pepper spray. Are there other weapons that you could technically brandish and get in trouble with for a crime?
There could be. We have all of our things that aren't intended or designed to cause serious bodily injury or death. So if they're not designed that way, if I held up a pillow, that's not designed to kill anybody, right? So that might be, you could brandish anything, I suppose. A taser, I've seen the Byrna pistols, the CO2, pepper ball pistols. So if it's not going to be considered a deadly weapon, going back to Emily's point, then if you were to display it as a warning, then likely we're talking about conduct on the misdemeanor end of the spectrum. But we move over to things that could cause, or they're designed to cause, serious bodily injury or death. So let's say a knife, probably going to be lumped together in the same category as a firearm, or a tire iron, or a crowbar, or a very long gaff stick or something like that. Well, then we're talking about maybe we are exhibiting a deadly weapon, because that's what it's designed to do. It's designed to cause serious bodily injury or death.
All right. So Andrew asks, so your gun is showing, you don't know it, but someone calls the cops on you. One, could that be brandishing? And two, what do you do?
Well, it's going to depend on the state. Frankly, we had a client
had this happen
where the police show up and say, okay, so what did they do? And well, they reached up, they grabbed the box of cereal, and their handgun was displayed. And the cops say, okay, have a nice day. And they leave. That might be the scenario, and I hope that's the case. And in states where open carry is legal, that's more likely going to be the scenario. But in most circumstances, inadvertent display, accidental display, non-intentional display, not a crime, generally. Yeah. But, we have seen cases where...
We went to trial over this once.
Yeah.
Yeah, we had a client who was he's actually carrying a long gun in a sling across his back. And police were called on him, and he was, sure enough, prosecuted. We took it all the way to trial. Now, the jury found him not guilty in less than 10 minutes, if that tells you anything at all. But still, and it was just a misdemeanor crime.
Right.
It's called disorderly conduct here in Texas, but it was brandishing. But that tells you something about kind of the life disruption. Over those couple of years where you're charged with these crimes, it's really hard to get a job. If you're charged with a felony, you're not going to get a new job at all. You're going to have to, go through the bonding process. You're going to have to check in with your bondsman all the time. You have to go in for random drug tests.
Hope a pandemic doesn't hit. And drag the case out for 2 years.
Exactly, right. But so, yeah, the chances are that if you're just minding your own business and someone is just a, wilting flower, and they see your gun and they're so scared of it they have to call the police, chances are in most places that the police are going to respond and realize you didn't do anything wrong and go about their way. But, you know, I mean, it was here in Texas. He got arrested for carrying that long gun across his back, and it was perfectly legal, and it took years and 2 appellate courts to sort it out.
All right, so we're getting a ton of questions now that I will say very, very difficult, but I want to give you a couple examples here. So Stephen asks, what if you just hold the knife but don't extend the blade? And then I'd say the same question with the gun. Is there a difference between holding the gun versus pointing the gun?
So, I mean, with the firearm in particular, we see that charged differently all the time. So, you know, and that's something actually police want to know about. And when I get emergency hotline calls and someone has said they've had to take their pistol out of their holster, one of my first questions is, where was it pointed? Because when we're putting together that self-defense statement for police, if it was pointed in a safe direction but simply in your hand, that's something I want law enforcement to know, because it does make a difference for law enforcement in terms of whether or not you'll be charged and what you'll be charged with. So pointed at the ground versus pointed at the person, big difference. I've even had differences in, you know, client interactions where, you know, let's say someone's doing something at your driver's side window, pointed at the person versus, you know, at sort of a low ready. It does make a difference in ultimately what you're charged with, not because of a definition of brandishing, but because of, you know, what was that minimum level of force that you were supposed to use. And a lot of times there's a big difference between having a pistol in your hand pointed at the ground versus in your hand pointed at a person. I mean, same goes really for any deadly weapon, I think.
Yeah, I mean, one of my, I had a client who that's what the case hinged on. What direction did he point his handgun? Mm-hmm. And he was in his vehicle. He's parked at a gas station, and you know, this group of people said, hey, this guy pointed a gun at all of us. And that's the information that the cops received on scene. That's the information that was conveyed to the district attorney's office, and he was charged, dragged through the system. You know, and it took a while, but once we found out, hey, this giant mob of people who were so scared that they all stood around his vehicle, you know, camera recording him. Once we got our hands on their videos, it showed, you know, he had it in a low ready pointed down across his body, and it never left the threshold or never went up, you know, above window level inside of the vehicle. And that ended up causing his case to get dismissed as soon as we got those videos. But obviously compounded with the fact that these people clearly weren't scared of the way he was behaving.
I remember that case, too. There was a lot to that one.
Yeah, yes. But the low ready in that case made a difference. And so, yeah.
Okay, so a lot of folks think, oh, I've just done the least, you know, the most minimal act that I can. Put my gun away, the other guy goes away, nothing has happened. What do you guys recommend after an incident like that?
I mean, you call your attorney because they need to advise you right away. I mean, you need to speak to an attorney.
And don't wait 30 minutes to call your attorney, because there are, I mean, if it's something we want you to report to law enforcement, we want you to report it quickly.
Right.
Because just generally speaking, right, you've got 2 parties to an incident. The first one who dings up on that 911 call is the victim. And that's going to be the assumption that law enforcement uses going forward 99% of the time.
Right.
So, you know, and there are times where, and we want you, I mean, if you're a LawShield member, like that emergency hotline is your best bet to get to, you know, one of, you know, your attorney very quickly, because, you know, we want to be able to tell you either don't call that in. You may have, you know, you may think that you used the least amount of force you could, but that was not legal. Don't call it in and don't say a word if approached. Or we might want to say, absolutely, you need to call that in, but we want you to ding up as the victim before the bad guy calls with a different story. Hang up with me right now. Call it in right now. So.
Right. So you were at your kid's elementary school and you pulled your gun on a magazine salesman. You might advise them, we don't need to be calling the police right now, but if you were attacked by you know, a group of criminals at a gas station, you absolutely want to be the first one on the 911 call. And just as an FYI here, a core of our program is our 24/7, 365 emergency hotline. For more information about that, there is a link on the description to this page. Click down there, get more information about the hotline and U.S. LawShield. So here's another one. Is it a crime to accidentally display the firearm, but then follow it up with, say, threatening words or threatening conduct?
Now that's an interesting question. So that initial accidental display in most places is not going to be an offense in and of itself, right? Because generally speaking, we've got this spectrum of mental states, right? And you have to have both mens rea and actus rea. So you have to have, in order to create a crime, you've got to have the guilty mind, you've got to have the guilty act. So we've got, you did something intentionally, you did something knowingly, you did something recklessly, and then you can do things negligently. And generally speaking, things that are negligent are accidents, and accidents aren't crimes. So that general first oopsie-doo, right? I displayed my firearm. You are probably okay. But then your actions after that, I mean, not only is, you need to be justified in the threat that you made afterwards, but I think you're opening the door for law enforcement, I mean, Richard, you can agree or disagree, for prosecutors, police officers to go in and reinterpret that accident before, which may have been a true accident, but they're going to say, we are going to divine your mental state from that first action based on your follow-up actions, which we talked about that a little bit in a previous segment. I mean, that culpable mental state comes from, in part what you did before, during, and after the incident.
No, I mean, I 100% agree. And that's exactly how they do it. If you say, I had no intention of threatening this person, but the before is their gun was displayed, or when a district attorney is listening to this on their intake phone, a cop calls in and says, hey, I think this crime was committed. Well, give me a rundown. What's going to get communicated is this guy flashed his gun, they exchanged words, then he threatened him. And then, the person felt threatened, so they called 911. So we saw this before, during, and after. And if I'm the DA on the other side of the phone, well, to me, that sounds like this person, brandished their firearm.
Yeah, it wasn't an accident.
It wasn't an accident. They're not going to, and this comes up over and over with law enforcement, and you hear this in your Miranda warning. What you say can and will be used against you, not what you say can and will be used for you or in your defense. Everything, their evidence collection machines to find material that would show, hey, this person was in the wrong, not this person was in the right. And so we see that come up time and time again, and that's why just polite society. That's the way to operate.
Okay, well, Dave asks a very good one here. So say we all know someone just hollering at you with no more threat whatsoever. Can't shoot them, and almost certainly cannot pull your gun on them. Can you holler back, hey, I've got a gun, go away?
Well, that is going to be a use of force, right? So, and most places, verbal threats alone do not justify a self-defense response. In order to start at that lowest level in the use of force continuum, I'm armed, I'll use it if I have to, get out of here. Just make sure there's something, like, I like to think of it as words plus, right? So that person who's hollering at you, it's, okay, they are, they're yelling at me, maybe now they're yelling a threat. Maybe now they've changed their body posture and it looks like something, they've moved to a defensive posture, an offensive posture, they're going to come do something. Maybe they take a step towards me. Words plus one is when your use of force continuum starts.
Yeah, we see that pop up in state after state, that using force or deadly force is never justified in response to verbal provocation alone. That's the sticks and stones may break my bones rule, right? Can't use force or deadly force in response to verbal threats alone, but verbal threat plus, and it could be, you need to be able to articulate this, or because at the end of the day, you're going to have to persuade a jury that what you did was reasonable and immediately necessary under the circumstances. And so if it's only, verbal provocation or verbal threats, that alone is probably not going to be sufficient. So you have to be certain that, your conduct, that you're doing it to defend yourself at the end of the day. And so words plus something else.
Right. I'm about to come over there and I'm about to do this thing to you. Very different with that present ability to act than me just yelling at you about, something that's offensive, right? A&M sucks, that's going to offend Richard. And, that's not enough for Richard to say that again, I've got my gun on me, right? So.
Got it. Okay, so they can holler at you, but you cannot holler back that you have a gun.
Well, cannot be a holler back girl unless there is a plus one. Yes, that's correct.
Well, and the one other thing that I'll add to is juries don't like, they love this, and there's no better term. We use the term innocence. They like this person who's just and I say this probably every single live stream, they like this innocent person beat bopping along and they're forced to respond to a threat. That's what they like. They don't like it whenever, a person takes a step and then you increase the threat by and just you keep working the person up. They don't like that building momentum or that building threat, that escalation of the event. And because juries are going to hold it against you. They want you to be the cool, calm, collected person that's trying to de-escalate, that's trying to avoid confrontation. And when they see someone just egging someone on, you take something, and it happens, where maybe a use of force may have been justified, or maybe that verbal threat in the example would have been justified. But because it keeps getting escalated, it ends in someone dying. Then they're really not going to like that.
Yeah. And remember, because people are thinking, well, I've looked at my state's law and I don't have to do it that way and I can engage. And sure, black and white in the law, absolutely. But you have to remember that we're not talking just from I've read the penal code perspective,
right,
but from a trial lawyer's perspective. This is what we see with juries. And just because it's black and white in paper, juries are wild animals. You cannot control them. You cannot predict them. You try your best to get good jurors who are firearm friendly and self-defense friendly, but ultimately you do not want one thing working against your client. And if that one thing is you yelled at me and I flipped the bird, and then and then that provoked, you just don't want to see it happen.
Well, and I've spoke to a jury after a trial, and the judge in that case read them, I want to say 20 pages of instructions of dense legalese of all these conditions, and then they navigate their way through, and is the person guilty or not guilty? And I was talking to them afterward, and they took an initial vote at the very beginning. They said who's right and who's wrong.
Yep.
And it can be that simple, and you don't want to be perceived as, hey, that person was in the wrong.
Right.
Because that's how real people operate. We would love to think that they meticulously go through the rules and they follow the court's instruction, but human beings, we're not built that way, and so you don't want to be the person in the wrong.
Yeah, I can't tell you how many times we've talked to jurors after a trial and, what did you think about the case and what did you rely on? And they said, yeah, the key for us was X. I'm like, X? What are you even talking about? What does that have to do with this case?
I barely thought twice about X.
Yeah, and they think that was the key to the entire case. All right, we're going to try to follow it up here. Maybe one or two more questions. We got a good one here is, does the same law apply? And can you get in trouble for brandishing if you happen to not be carrying, but yet pretend like you have a gun? Pretend like you're reaching for the gun and threatening that, hey, stop, I have a gun.
I really like that question.
Yeah, I do too. So, just because of the society we live in, there is something criminalizing virtually everything. So there is some law out there that's going to cover, and in fact, we've even looked at some states' penal codes that cover essentially pretending to have a weapon and threatening someone. You can still put someone in fear for their life without a weapon, right? And be charged with a crime. It's just not going to be a brandishing crime, right? Do you have things to add to that?
No, I would just say, most states, going back to that use or exhibition, there would have to be some demonstration that the person, in a lot of states, and again, this is going to vary, but there has to be the presence of a deadly weapon. And we see that come up with, kid has BB gun that looks realistic. And they, they feel high in the saddle and they're pointing it at somebody. In those cases, we see get dismissed because that's not a deadly weapon. So I imagine that would fall into that same category as there's not an actual deadly weapon. But to Emily's point,
there's something else you're going to be charged with, right?
There's absolutely something you're going to get charged with.
It's not going to be brandishing. It's going to be assault by threat, right? It's going to be something.
Yeah.
All right, well, let's do a last question here. And this is a good one. This is one that a lot of people are likely to run into. So I'm inside my house or my apartment or my condo, and I hear something outside that does not sound right. And I go out with the gun in my hand to investigate. Could I get in trouble for brandishing?
Emily?
Oh, sure. The answer is sure, sometimes. Most states' law build in protections to account for this, right? We were talking about some of them earlier. You're on your own property. You have these sorts of build-ins that would say, look, you're not going out to threaten someone specifically. You hear something, you're in your home or you're on your curtilage. However, we actually had a client charged for this exact thing here in Texas, in which he heard something on his property. He grabbed, I believe it was a handgun at the time, and he walked the perimeter of his property. Now, he also lived right across the street from an elementary school, which did not help, and people saw and they were threatened. But, and ultimately the case did get dismissed. But the answer is there are protections built into the law generally, and in most states for that kind of activity. Does it mean that someone's not going to, an innocent bystander, let's say, is not going to get scared, call the police, and you're not going to get charged? It does not mean that. Right.
No. I mean, and I saw this case come up during the riots during 2020. Someone didn't even exit their house. They stayed inside their house. They were in a window watching large crowds of people, burn and destroy, and they were there with their gun. And in that case, I think the police made the wrong decision because they said it's easier to arrest this one person than this entire mob. And so I, from a practical standpoint, I get it. But that homeowner was within their rights to protect themselves, protect their property, their life. But in that case, they said, hey, look, this person they can see the firearm in plain view from a public place. And in that case, they charge the person. So it could be very legally perilous.
Yeah. I mean, I think there's a lot of dismissals that would happen from that sort of situation.
Right.
But not necessarily a lack of charges.
Right.
Yeah.
Ouch. Well, thank you again, everyone, and thank you, Richard and Emily. Excellent presentation. Just as a reminder, on the description to this event, we have everything you need to know about brandishing. Just click down there to read that article. And then in addition, for more information about U.S. LawShield, 24/7 emergency hotline, there is a link down below where you can get information about the program, or if you want to sign up. Thank you again. We appreciate everybody watching and attending. Thank you.
Thank you.
See you next time.